Ladies and gentlemen, thank you for taking the time to join us today, and a warm welcome to the M&A Masters webinar, the seventh in our ongoing series. My name is Anuj, and I'm a partner in Khaitan & Company's corporate M&A practice based in our Singapore office. It is a privilege to host you for this session, and I extend my warmest welcome to each of you, whether you are tuning in from India or from across the world. We can go to the next slide with the webinar agenda. The M&A Masters program is designed to deliver a sophisticated platform for learning and dialogue on contemporary M&A issues, bringing together experienced corporate executives, in-house legal teams, investment bankers, intermediaries, and others who are engaged in or keenly interested in M&A in India today. Our focus for today's session is cross-border M&A, a topic that continues to shape corporate strategy and investment flows in profound ways. On the screen, you will see the agenda for today's discussion. If you have questions at any point, please use the Q&A facility in the webinar portal. While we may not be able to address every question during the live session, we will follow up by email after the webinar. And finally, as a matter of course, a copy of the presentation, summary notes, and a recording of this session will be shared with you after the webinar. As part of the introduction to this webinar, note that as Indian businesses continue to expand globally, cross-border M&A has become a vital tool for growth, market access, and diversification. Yet executing an outbound deal is far from simple. It means navigating Indian regulations, overcoming financing constraints, understanding local sensitivities, adapting to foreign legal frameworks, and managing the complexities of post-deal integration. Today's session will draw on expert legal perspectives to explore the key elements of a successful outbound M&A. We will talk about regulatory and financing considerations. We'll talk about market-specific factors and sectoral sensitivities, and the legal and cultural nuances that can define post-acquisition success. We meet at a time of real momentum. In the first quarter of 2025, outbound deal value from India tripled compared to the same period last year, a clear sign of India's pivot towards strategic global expansion. We've had some notable deals in the last few weeks, including Tata Motors' $4 billion cash acquisition of Italy's Iveco, its biggest move since Jaguar Land Rover acquisition. We saw Sun Pharma doing a $355 million purchase of Boston-based Checkpoint Therapeutics to boost its oncology pipeline. We saw Titan do a transaction in the Middle East, in Dubai, to use Gulf as a gateway to the US and GCC markets. This surge spans diverse sectors, from AI, energy, healthcare, fintech, e-commerce, and extends far beyond Europe, North America, to Middle East, Southeast Asia, Australia, and Latin America. At this moment, I want to introduce to you my panelists on the session today. Everyone who is registered for this webinar should have already received a summary of our presenters and their credentials. Suffice it to say, they are highly experienced colleagues and experts in this field, eminently qualified to share their insights. As a firm, we have advised on some of the most significant cross-border deals in recent years, and we've seen firsthand how informed decision and timely execution are essential to the success of any transaction. Our panel reflects exactly that caliber of expertise. Joining are my colleagues and co-partners from across Khaitan's offices, Nikhil Narayanan, Samir Shah, and Tanvi Kumar, each of whom has advised on some of the most complex and notable corporate cross-border deals in India. So let's get the discussion started. Nikhil, if I can turn to you first. Uh, my first question I wanted to pose to you is, when planning an offshore acquisition, what, in your view and experience, are the broad factors an Indian acquirer needs to consider?
Yeah, thank you, Anuj. And it's a great question because planning is really everything. It's critical to success. I would say that there are three broad considerations which define success. The first is probably the most obvious point, which is it's really important that the acquirer has a good understanding of the market in which the target operates. Market practice will be different. There may be national security, uh, consent requirements, or approval requirements that are needed, competition approvals. There may be particular things which are local, such as works council requirements. So there are a whole host of considerations which define timeline, which define approach to a deal. It's important, very important, to get the right advice so that issues can be anticipated in advance, and so that you can plan for a seamless transaction, and so that timelines can also be set in a realistic fashion. That's one. Of course, probably a subset to that point is if it is a public deal, then it's even more critical that you get that understanding of the deal environment, what's possible early, because your behavior and conduct will need to be regulated at a much earlier stage. So that's the first issue. I think the second point that I would say is financing. No deal can happen without the financing to pay for the acquisition. And so thinking about that and having any financing in place early on is important. In public deals in a number of markets, there are certainty of funds requirements, which means that there needs to be committed financing with very limited or no outs. And so that needs to be then parallel tracked with the M&A acquisition process so that there's no bottleneck at the end. And even if it isn't a public deal, quite often sellers will want some comfort around certainty of funding. So this is something that does need to be planned in advance. The third factor that I would say is just a sort of common sense planning approach, taking into account things such as time zones, and an acquirer's own organization and the team that it puts together with its advisors. For instance, who's running the deal? Often for the more significant cross-border deals, there will be a commercial person, a business person, and also a legal point of contact, and they're both important. And they sort of drive the transactions. There's probably and often a need for a steering committee with periodic calls to make sure that issues are bubbled up at the right points of time, and for periodic calls. So planning things of that nature can make a transaction far smoother.
Great. Great. Thanks for that summary and thanks for that uh, brief. I wanted to, Nikhil, you and I have spoken on the side about interest rates, where they are today. All of us had expected that perhaps with high interest rates in the US and elsewhere, we'll see a slowdown in deal activity. But at least as far as India is concerned, we seem to have been untouched. And thankfully, those predictions of ours have come wrong. So despite higher interest rates, at least in India, we continue to be fairly busy with deals. Okay, let's move on. The next question, Tanvi, can I pose you the next question? You've advised on many transactions on the regulatory aspects around cross-border acquisitions. Can you guide us and focus on the regulatory aspects which would be applicable to the matters that Nikhil highlighted in the former question?
So thanks, Anuj. Firstly, great to be a part of such an experienced panel, and the topic is quite topical as well. In an environment where we are looking at tariffs, where Indian businesses are looking to sort of solve that through global acquisitions. I think this is a very topical, issue. And going back to your question, I think on the regulatory aspects of overseas investment deals. I think just to break it down, there are certain key aspects to consider while Indian companies seek to make overseas investments. Number one is the investment structure. Number two is nature of investment, whether it's debt, equity, nature of the business activity of the investee company, the investment limits which are prescribed under Indian regulations, and the pricing norms that are prescribed as well. So now, just to start off, I think overseas investments are permitted in a foreign entity, which refers to an entity formed, registered, incorporated outside India, and it includes International Financial Services Centers in India, which have, and each of these have to have limited liability. Now, this is pertinent because IFSCs have been recognized as overseas direct investment, and these entities are considered as foreign entities within the ODI framework. The introduction of limited liability concept clarifies the eligible entities in which overseas investments can be made. Accordingly, these investments can be considered in foreign entities which are in the nature which are constituted in the nature of partnerships, LLCs, limited liability, organizations, etc. uh, the ODI regime permits investments in both equity and debt capital, subject to limits and conditions prescribed under these regulations. And these regulations prescribe different limits, conditions, etc., for different modes of investment, being ODI, which is overseas direct investment, overseas portfolio investment, and then the regulations also prescribe for other financial commitments. Now, ODI means in acquisition of unlisted equity capital or subscription to memorandum of association of a foreign entity. It includes investment in 10% or more of the equity capital of a listed foreign entity, and it even includes investment which are less than 10% in a listed foreign entity, but there is an element of control involved. OPI, or what is overseas portfolio investment, is basically any investment in foreign securities other than ODI, largely meant to cover investment in listed foreign securities which are not falling in the bucket of the 10% and the control that we spoke about. Then it also permits investment in debt instruments in an entity, which is a foreign entity in which ODI is permitted. So, the regulations also permit non-fund based facilities such as guarantees, which are then counted towards the total financial commitment of an Indian investor entity. So those are the different modes. Now, the nature of business is also important because an overseas investment by a person resident in India is permitted to be made in a foreign entity which is engaged in bona fide business activity. This can be made directly, it can be made through step down subsidiaries, it can be made through SPVs, but bona fide business activity is basically any business activity which is permitted under laws in India and the host country. So, therefore, investment in sectors like crypto, gambling, gaming becomes tricky and may not fall particularly as permitted sectors within the regulations. The regulations expressly as well provide for certain sectors which are restricted. So, for example, real estate, gambling, dealing with financial products which are linked to Indian rupees, they require specific RBI permission. Now, as has been, the regulations have been the same as far as investment limits go, which is the same, cap of 400% of the net worth overall as a cap on an Indian company making any financial commitment in foreign entities, and this itself is then subject to a cap of $1 billion in a financial year. So, therefore, even if the 400% net worth requirement is met, but the investment is beyond the 1 billion USD cap, then an RBI approval will be required. The regulations also prescribe pricing guidelines. So, for any issue or transfer of equity capital of a foreign entity, it has to be subject to a price which is on an arm's length basis. It has to be backed by a valuation report, and the powers to ensure compliance with these pricing guidelines have been delegated to authorized dealer banks. I think the one area which is interesting and is pertinent, especially in light of the deal structures that we see, are the rules around round tripping. So there are various foreign entities with substantial operations in India, with investments in India, and the regulations open up doors for such entities as well to access Indian capital, which was earlier frowned upon as round tripping. So the regulations do permit for such foreign entities with investments or operations in India to have access, and it can be done as long as the investment into India is resulting in a structure which is not more than two layers of subsidiaries. So so as long as the structure of investment is within this prescribed structure of two layers of subsidiary, then overseas investment in such entities is also permissible. So overall, I think it's the regulations in some ways give an impetus for Indian companies to explore expansion in global markets. Yeah, Anuj, over to you.
Great, and thanks for clarifying and simplifying that fairly technical topic, which we as practitioners may be very familiar with, but it gets difficult to explain in simple ways, and I think you did it very succinctly. So thank you for that, Tanvi. My next question, maybe Samir, I can bring you in now. And my next question to you is, what are the kind of national interest legislations from a foreign investment perspective that are relevant? Would you like to talk about some examples?
I think that's a excellent and highly relevant question, Anuj. We move from Indian regulations to uh, regulations in the relevant jurisdiction where clients are looking to invest. And I can tell you these national interest and foreign investment screening regimes, they are globally becoming ever more complex and ever more critical. And they become a very important part of the pre-planning exercise of any cross-border deal. And these are not always straightforward, very similar to how sometimes Indian regulations are meant to blur the edges to leave some discretion with the authorities. Speaking of examples, if we look at the US, they have a very powerful committee on foreign investment in the United States, or CFIUS as they call it. And this reviews foreign investments for potential national security risks. Their definition of national security is incredibly broad, and it encompasses not just your traditional defense related or critical technologies, it can go into infrastructure and even sensitive personal data. And the penalties for non-compliance are really crippling and severe. A key risk is that even if a transaction is not notified to CFIUS, CFIUS can subsequently call in the deal for a review long after it would have been closed. And if they find that there is a national security risk, believe you me, they have the ability to compel the parties to actually unwind the transaction. Their traditional cross-Atlantic allies in the United Kingdom, they have the National Security and Investment Act, which mandates notification for, I believe, 17 sensitive sectors, which includes defense, artificial intelligence, and advanced robotics as well. If you see very close to home, they have the ability to call in transactions for review. And a very recent example is Bharti Televentures' acquisition of a stake in the BT Group. The deal was in a very sensitive sector which was subject to a review, and it was ultimately cleared, but only once parties agreed to certain conditions, including the establishment of a national security committee to oversee the government's strategic work. What otherwise may have seemed to be a very routine deal can very quickly become quite complex. If we go to Europe, look at France, they have a foreign investment screening regime that covers a wide range of sensitive sectors from public health to raw materials to energy. Look at Italy, they have what is called the Golden Power Regulation, which covers, amongst other things, energy and transport. In one of our recent transactions in the mobility space, there was some unpredictability, and it led to a significant hurdle for our clients to make up their mind. And I would finally bring you to Germany. This is a personal favorite. You have the Federal Ministry for Economic Affairs and Climate Action, or the BMWI. This oversees foreign investment screening. And what is most interesting is that this is not just restricted to equity investments, but in certain cases, even technology transfers involving sensitive or dual use technologies need to be reviewed. In one of our deals for one of our clients, we had to very carefully assess not just the share acquisition, but also the subsequent plan for transfer of certain proprietary manufacturing processes. A very practical tip is that Germany, if you file with the authorities and they do not respond within a certain amount of time, the approval is deemed to be granted. I would really say the key takeaway is that these legislations are growing and they're a non-negotiable part of cross-border M&A. And the more proactive due diligence or expert advice that we see early on in the deal process, this is no longer just good practice, this is now essential. And if we are not able to manage these issues properly, we could lead to a deal being blocked, unwound, or even penalties. Over to you, Anuj.
I think
Just one thought, just one thought on that, Samir, just to come in. I think the point that you make that it is not just the deal itself, but some of the other ancillary aspects around it, whether it's technology transfer or data or anything else, themselves being capable of action under these various regulations is an important one. In fact, in the US, about a year ago, in August of last year, what was the largest CFIUS fine of $60 million was imposed in relation to T-Mobile's merger with Sprint. Now, as part of that merger in 2020, CFIUS cleared the merger, but it required the parties to enter into a national security agreement with the government. And that we see as being increasingly common. Uh, Subsequently, it was found that the terms of some of those of that agreement were breached in relation to certain data access provisions, and this large penalty was imposed. So this illustrates the point that the consequences can be later after closing, and that they don't only relate to the acquisition itself. It relates to some of the other conditions or sensitive areas as determined by the relevant state authority.
There you have it.
great.
There you have it.
Yeah, thanks for that input. And I would just add to that, outside of CFIUS, and I think this is a protectionist thing going across countries. We saw the US Steel, Nippon Steel deal play out, which was largely driven by politics, and Nippon Steel was asked in the US to make concessions outside of the rule book. But this is a trend I think we see everywhere these days. So therefore, it becomes national interest. Evaluation becomes very, very critical, especially in large ticket deals. Now, Nikhil, let me come back to you. We know you have a passion for diligence, and it is we are very familiar with diligence of Indian targets. But lately, we see this trend of Indian companies going overseas, doing large acquisitions. What fundamentally changes, and what is when an Indian acquirer goes about undertaking diligence of an offshore target, things that he should be specifically mindful of?
Yeah, this is a great question. I think there are two aspects. There are two overarching points that an Indian acquirer would need to bear in mind. The first is balance, because obviously diligence is important in any deal, but particularly when a company is looking to acquire a target in another market, a market that it may not be familiar with. There is obviously the desire on the part of its management to dig deep and to get as much clarity around the various issues as possible, because it's the first time usually the first time that the acquirer is venturing into this particular market. We see that in reverse in India. When international parties seek to invest in India, there's often a lot of deep diving into a number of issues just to get the buyer comfortable, and so that's naturally always going to be the case. But what's important is to balance that against what's appropriate and what's possible. So, for instance, in a public M&A deal, uh, diligence is likely to be relatively light in comparison to a private deal, because there's a risk of leaks. Frankly, a lot of the information be public already because of various listing requirements. So, that will condition those types of deals. Similarly, in private deals, of course, there's far more flexibility, but one needs to be mindful of the specific acquisition dynamics. So, for instance, if it's an auction, a competitive process, information will be made available in a phased manner. So it's important to be aware of these sorts of dynamics so that the diligence can be structured and expectations can be managed appropriately. So the first point I would say is balance. The second point I think that is important is just to get the focus right. Um, you know, often in offshore acquisitions, things move fast. It's particularly the case in auction processes, but even otherwise, exclusivity can be for a limited period, and it's really important that the buyer, while it wants to have as comprehensive a picture of the target as possible, focuses on what really matters. And so setting the appropriate scope is important, setting appropriate materiality thresholds and look back periods and that sort of thing. That's important. And over here, of course, the acquirer will be guided by its counsel. And so it's very important to get the right counsel so that an appropriate balance is maintained between getting all the information that gives the acquirer comfort to proceed, but at the same time being consistent with the type of deal, the deal dynamic, to enable the parties to go forward, in a useful and constructive manner.
Great. Thanks for explaining it well. And with the complexities of politics, geopolitics, all getting mixed into the deal making scene, I think the scope of diligence further gets complicated, and therefore the need for a broader perspective when implementing those deals. Let me come back to you, Tanvi, now. Uh, why don't we talk about the various forms of acquisitions? And I thought we'll seek your perspective on what are the various forms of acquisitions that an acquirer can consider.
So, Anuj, like M&As in any jurisdiction, outbound M&As in India can, from India can also be structured as acquisition of securities or acquisition of assets. Again, funding structures and tax plays a huge role in determining the most suitable acquisition structure. But the key considerations remain: what value is sought to be consolidated, what is the ease of implementation of such a transaction. So, for example, if it's in transfer of assets that is contemplated, that may have areas such as transfer of regulatory licenses, requirements for the acquirer to seek the acquirer or the seller to seek government approvals. There may be requirements to assign or novate contracts, which may be time consuming, which may not be practicable. So that's one key aspect which is considered. Seller's commercial preference: where does it want to receive the consideration? What is therefore the resulting tax implication on the seller? So these are certain considerations that all play into the acquisition structure. Obviously, when we are talking about transfer of assets uh, in an offshore jurisdiction, that may require incorporation of a local entity by the Indian acquirer in that jurisdiction. So therefore, structuring the fund, structuring, firstly incorporating that entity, then structuring the funding of that acquisition vehicle, compliance of such offshore acquisition vehicle with local laws of the host countries. So all of this needs to be considered when deciding the appropriate transaction structure. Of course, the ODI regime itself permits acquisition of securities as well as investment in an offshore entity by subscribing to memorandum, which will then result in therefore incorporation of the acquisition vehicle. Of course, it's subject to compliance with the regulatory requirements and conditions that we spoke about previously. But when deciding, I think these are the key elements, and both the structures are enabled by Indian regulations.
Okay.
Understood.
And broadly, the trend, sorry, I was saying great. And broadly, the trend that we see is the regulators getting more comfortable with Indian companies going out, approvals coming in time. They understand perhaps the need that the world is integrated and technology may sit at one part and other critical items of the supply chain may sit in the other part. So we see a lot of flexibility from our regulators compared to what we used to see a few years back when it comes to offshore acquisitions. But as a segue to my former question, Tanvi, why don't I ask you uh, uh, that other than equity participation, what are the other forms of collaboration do you see clients exploring when doing cross-border transactions?
Sure. So I think, especially in situations where parties are still exploring synergies, they are still formulating long term strategy, where financial viability of a project is still being weighed. Often we've seen parties start with strategic collaborations, which may be in the nature of technology collaborations, and they may be in the nature of marketing arrangements, distributorship arrangements, joint R&D projects. So we often see more such collaborations, of course, in technology sectors, or where the nature of activity is in some ways supply or trading. Of course, such arrangements are outside the purview of the overseas investment regime that we talked about previously. But then there are other aspects to be looked into carefully. Besides tax, there will be implications under Indian laws on payment of royalty, on structuring these distributorship arrangements, funding and sharing expenditure of such collaborations in an offshore jurisdiction. So all of these have to be looked into clearly from from an Indian law perspective. But yes, there are various modes of cross-border collaborations that we are seeing in the market.
And in fact, Anuj, if I may, Tanvi makes a very
Yeah.
good point that some of these collaborations are outside of the equity sphere. And wherever you have national interest legislations, we have some geopolitical issues with our land bordering countries. And there are occasions where collaborations are pitched and started on the basis of either technology or know-how or product knowledge or so on. And then hopefully, as and when these national interest legislations relax, we could look at converting those into equity partnerships also. So I think that's a great structuring tool being used by a lot of clients.
Yeah, absolutely. It could, especially in the case of, if I can just supplement from my experience, and we read this commonly, let's just see China. They're so good at certain technologies when it comes to clean tech. And you mentioned land bordering country, and we have the demand. And we have the Press Note 3, which restricts the investment. So we suddenly see a trend of a lot of technology arrangements there. So that kind of structure is again back in vogue. Okay, let's move on. Nikhil, my next question is to you. And
Yeah.
the question is, the approach to M&A will necessarily vary across markets. And as we operate across various markets, what are the key differences to note?
Yeah, I mean, it's an excellent question, and it really goes to the heart of it because, there are obviously a number of common threads and commonalities between how M&A transactions are structured in different parts of the world, but there are differences, and it's understanding those key differences that makes all the difference in terms of ensuring a successful outbound acquisition. So, the starting point is obviously to understand the nature of the deal. In a public deal, everything will be completely driven by the local requirements. So, for example, if it's a public takeover in the UK, for instance, there are any number of requirements, from financing certainty of funding, governing the conduct of the parties, what they can and should be saying, stake building, concert party issues, confidentiality considerations, disclosure issues at certain thresholds. So there's a lot to be aware of. And the point is that it will regulate behavior from the very start, from the get-go. So it's important to get that advice, and it will be completely local. There's no point trying to draw parallels in that circumstance to things that we have or may not have in India. It's just a different environment, and one needs to accept that. Um, as far as private transactions are concerned, the differences focus on deal terms. In India, we're used to relatively buyer-friendly transactions. Warranties are given on an indemnity basis. There are a large number of conditions, including material adverse change and many other features which are more buyer-friendly than you would often see in the UK or Europe, where because it's been such a seller-friendly market for such a long time with so much cash coming into the market, deal terms have, in general, been a lot more seller friendly than they are here. So conditionality is much more limited than you would see in India, and things like MAEs are hard to obtain. Um, English law documents have warranties which are not on an indemnity basis, and I'll explain this. I'll come back to this point in a minute. If you go to the US, it's a different ballgame. They have their own requirements. And in general, they are very, they're buyer friendly, perhaps more so than in India. So that's on the deal terms. It's also how the documents look and feel. And those are bound to be different in each country. Although in India, although we are sort of US style in the sense that we uh, protect the buyers quite a lot in our market, uh, the look and feel of the documents are still very much like English law governed SPAs. In the US, the documents are going to be and look and feel very different. But the main thing to be aware of in all of this is not to try and impose local standards or, to say that, to be afraid of the unknown. Standards are going to be different. Market practice is necessarily going to be different. And as long as you have the right advice, right advisors to advise you on the implications, to guide you as to what is appropriate and what is not appropriate, what is customary and what is not, an acquirer can then efficiently map that against its own risk matrix and what is likely to work and or not likely to work internally. And so getting the right advice on that will really help understand and navigate, the differences in market practice.
Great, thanks for that explanation. I think we can, Samir, let's come back to you and moving away from the differences that we see across markets. Why don't we come to listed companies in India? And in your view, what are the material differences where the Indian acquirer is a public listed company compared to the acquirer being any other form of entity?
I think that's a very interesting question, Anuj. And a lot of it really goes back to communication and governance standards because those are very heightened the minute the acquirer is an Indian listed company. So I guess even from the non-disclosure agreement stage, you will see a lot many more provisions around dealing in securities or what sort of information can be made available to whom and how closely one would protect the identity of the potential bidder and or acquirer in this particular scenario. But more importantly, what we tend to do in our transactions where we are representing an Indian listed acquirer is sensitizing the other side that eventually, whenever the transaction goes through, we will have to make a stock exchange announcement, and a lot of information, including perhaps the price, will have to be publicly made aware to people. So that's something which, let's say, smaller sellers or smaller companies may struggle with. They may want to keep the deal details more intimate, but with a listed acquirer, that's not necessarily possible. I would also say that this communication for clients tends to be something they want to plan, let's say, with a results announcement on a quarterly basis or with any other significant events that they're planning to announce, simply because they also want to gauge what sort of an impact will this market communication have on their price. And we've seen instances in the past where listed acquirers have actually, for example, planned analyst calls just to explain in more detail and more graphic detail as to what is the thinking and business rationale behind a particular acquisition. I would also say that for some of our larger listed clients, there is also now this requirement that if there are market rumors which are not of a general nature and they could potentially impact price in a material manner, then they're obliged within a certain amount of time to either confirm, deny, or clarify the rumor. Now, let's say if an Indian listed acquirer is chasing a particular transaction, wants that to be kept under wraps, but if there's a market rumor around it, then it really puts that situation in a little bit of a spin. And the last item, I would take a leaf from what Nikhil just said in terms of due diligence. All else being equal, you would diligence based on what works for the local environment, depending on whether it's a, let's say, a listed target or whether it is a privately held target. You'll get a very different set of information and availability of information. But when it comes to an Indian listed acquirer, to the extent the process allows on the sell side, the Indian listed acquirer will also have to maybe go a slightly extra mile to address additional diligence information because independent directors are likely to ask this kind of information. Over to you, Anuj.
Yeah, and just to supplement, that last point that Samir made, like anywhere, public listed companies with independent directors, their boards will have to have a degree of oversight. So often you find that, at least for the last of the more significant overseas acquisitions that they undertake, these are subject to periodic review by the board. It's not just that they approve it at the end. There's often a steering committee of the board, that monitors periodic progress, and information flows through to them. It's usually distilled and crystallized to the high level points, whether it's diligence points or deal risk points or what have you. But they do keep, they do monitor that closely, both on an ongoing basis and obviously at the time of the the ultimate approval.
Great, thank you. And I would just add, if I may, we see it again and again, the amount of close attention our regulator pays to deals done by listed companies. A regulator who seems so committed to ensuring no market manipulation on stock price, etc. But it's fairly standard after every deal for them to ask us for the list of advisors, tracking everybody's stock purchase and whatnot. But there's a huge amount of scrutiny on that aspect, and which further entails all the in-house work that entails for us as advisors to keep a checklist on how data is being shared, etc. Okay, so why don't I come back to Tanvi. Tanvi, now in this very complex environment, which only seems to, while the deal sizes and the numbers continue to get bigger, the environment continues to get complicated. And in this very complicated environment, how does the acquirer, in your view, protect value?
Right. So, Anuj, I think protection of value in offshore acquisitions, I think, is should be looked at from the perspective of two broad risks. One is the exchange control risk, and the other is the risk of overpaying for the target. Now, as you rightly mentioned, with the current looming global uncertainty, the currency risk will only be heightened, and of course that there are some mitigative approaches and solutions that usually parties look at in the form of financial hedging instruments, but even those are expensive, and they're likely to get even more expensive with the current environment. But I think the hedging part is just an aspect of a cross border transaction when it comes to dealing with currency risk and exchange control risk. The second bit that I talked about, which is the risk of overpaying for the target. Obviously, the first gate is by the regulations themselves, right? Because the regulations do prescribe any such transactions being done on arm's length pricing. But I think in addition to that, there are various contractual solutions that parties often look at. There are arrangements for purchase price adjustments, which are clauses to adjust price based on net working capital, cash, debt, financial metrics at closing, based on actuals at closing, which can be trued up post closing. There can be models which are structured around deferred part of the consideration. There are relaxations which are available under the ODI regime to permit such payment of consideration on a deferred basis for sale of any equity securities between a resident and a non-resident. It has to obviously comply with the pricing regulations, and the transfer itself has to happen upfront by the seller to the buyer. But nevertheless, this is a solution which can be explored. There can be solutions around structuring the transaction with some earnout element. Earnouts are, of course, contingent payments, which are which are made basis future performance or achievement of milestones or achievement of certain financial parameters, and they can be very effective tools to resolve differences between parties on expected growth, future performance of the target entities, where in transactions where continued involvement of sellers, especially founders, is critical, post completion, to secure the future success of the acquired business. Earnouts can be used. They can be used to retain talent. They can be used to incentivize them. Of course, one point which is often negotiated in such structures is, how will such earnout be paid? Whether it's simply a holdback, which is just a promise to pay, or can it be structured as an amount being parked in an escrow, So obviously, depending upon the leverage of the seller or the buyer, these are discussed commercially and negotiated commercially. But again, from a regulatory point of view and structuring the deal, all of these options can be explored in order to protect, value and pay the right price.
Great. Looks like we have some tools available to protect value, especially in this environment where everything is getting disrupted. And we hear from our clients that you invest in a certain industry, and especially on the tech side, AI, whether the industry itself remains relevant or the growth gets significantly curtailed in a matter of very short period of time. So very uncertain times for several sectors, but looks like we have some tools available to protect value. Thanks for that explanation. Samir, let me come back to you for the next question. We've seen this for various Indian companies. One of the way to leapfrog innovation is to invest in startups and so on overseas. How should one tackle founders in a strategic investment of this nature outside India?
I think that's a very interesting question and something very close to my heart, because I would say a large part of what I've done in terms of offshore acquisition has been for Indian corporations who see strategic investments as overseas startups as really the only powerful way to accelerate or catch up on innovation. And more often than not, Anuj, the key to a successful deal very rarely lies in the valuation. It lies more in how you manage the founder relationship. And in my experience, while of course there are jurisdictional and cultural contextual challenges, the fundamental approach dramatically different from what we do here in India, because at the end of the day, we are still managing human beings. I would say the first and the foremost aspect is recognizing the distinction between the emotional and commercial aspects of the transaction. For a lot of these founders, the company isn't just an asset, it's their life's work. And they have a deep emotional connection to it. And as an investor, while it's of course our job to structure the commercial framework, we must do so in a manner sensitive to the legacy they've created. I recollect a deal in the United Kingdom where the founders were really resisting hard on standard liability clauses. And while any ordinary commercial investor may have seen that as a non negotiable, kudos to the client for having eventually narrowed the scope of personal liability very precisely and providing a very helpful capping on the financial exposure of the founders. I would say the second is really incentives and alignment. Tanvi spoke about earnouts as a part of value protection. I would also say they're a part of incentivizing the founders. And we've seen that if there is a good deal structure which aligns the founders' economic interests with the investors' long term goals, whether you take a long term incentive plan, you take some sort of stock options, all of these really incentivize, and the carrot very often works much better than the stick. Another very critical aspect is giving them clarity towards a clear exit. They'll happily hang around to help you learn the business, to earn from the business, but eventually they want to be able to hand over the keys and move on to other things in life. And in one deal in a European jurisdiction, our client wanted the exit to be linked to a lot of very commercial and non financial metrics like a net promoter score. And from a legal and commercial perspective, this is highly subjective and very unworkable. So we had to negotiate a more objective set of financial and operational triggers that were legally enforceable. Yet the founders agreed that our client could conduct an NPS survey. And the last 2 points, I would say really clear governance is very paramount. You need to give the founders the right set of veto rights so they feel respected, they feel valued. In one case, we were in Singapore and the founders were very concerned that they would get diluted. Our clients were very concerned that they would need to ramp up capital from time to time for growth purposes. The only way we could marry the two was to say, well, we will be able to bring in more capital, so provided it's at a price higher than our entry valuation. This is something which worked for both people. And really, the last thing I would say is on due diligence. Nikhil spoke about it. One live example that comes to mind. In one case in the UK, we were working with a set of two founders, and through integrity due diligence, we spotted that while they were giving time and attention to this company, they had created another company which had then run insolvent. And that led us to ask a lot of questions around the founders and really look at the business plan with a very different lens. So I would say ultimately, if you want a successful transaction with founders, it's all about building a relationship based on trust, empathy, and a certain human touch. Because while these aspects are not in legal agreements, more often than not, they're the glue that hold these complex partnerships together. Over to you, Anuj.
Absolutely. Absolutely. Very well put.
And
Let's
sorry,
move.
Anu, just coming in there before, I think the cultural aspects, we've touched on so many of the more technical points. But I think Samir's hit on a very good point because, in a cross-border deal, there will be, parties from two different parts of the world, possibly two different cultures, and bridging those cultural gaps, understanding what the other side is concerned about, and reaching out to them. I think that is really critical in sometimes in achieving a successful outcome.
Absolutely. Yeah, great points. Looks like we're nearly there. We are running a bit out of time, and we have a few audience questions. And I think uh, the best way would be perhaps we skip some of our questions. I see some interesting audience questions in the chat box, and maybe we pick those audience questions in a certain way. Nikhil, I'm going to pose this question to you. In some form, we were going to ask you, but we received this same question from someone, from a person in the audience. And the question is that how should one approach governing law and dispute resolution in transaction contracts? So we had this as part of our original list of questions, but it also came as part of audience Q&A. So Nikhil, to you.
Yeah, thank you, Anuj. Look, it's a question that comes up time and again. And obviously, the starting point for a lot of Indian acquirers is one of concern that, they're familiar with Indian law and they've done many acquisitions in India under Indian law. So they're comfortable with that. And then they see and ask for a different governing law, and it sometimes appears as being concerning. And there are concerns that, what am I signing up to here? But I think it's important to move away from that. It's going to be a very rare deal where Indian governing law is going to be acceptable to the counterparty. And I think the way to look at it, and to sort of unpack this, is to really step back and think, what is it that an acquirer, or frankly, in either party, is trying to achieve through the governing law and dispute resolution clauses? And the answer is simply to have a process which is fair and reasonable, where disputes can be resolved quickly in accordance with, commercially established and commercially sound principles. Now, if you get it from that lens, the issue starts to become far simpler. English law is often used in transactions not necessarily involving England and Wales, but cross-border transactions, because it is predictable, it is certain. There's a huge body of case law, and it's commercially very sound. It's a convenient governing law for many parties, and they choose to use it. If the deal is in the US, it may be that laws of one of the states in the US is applied, whether it's New York law or California law or something else. And again, I think the main thing is not to be worried about the choice of law itself, but just to make sure, as long as you get the right advice, and you have the right counsel providing you advice on the implications of the various provisions, what a party is signing up to, that's all that really matters. As far as dispute resolution is concerned, there's a usual debate between legal proceedings, litigation versus arbitration. I think the concern really centers around enforceability. So, for instance, looking at the reverse in India, a foreign judgment is only enforceable in India if it's from a reciprocating jurisdictions. And there are issues of that nature in other parts of the world. It's sometimes simpler, therefore, to choose arbitration because most countries in the world have signed up to the New York Convention, which makes arbitral awards, international arbitral awards, enforceable with very few exceptions in the member states, in the signatory states. And so that's a very useful way of ensuring global enforceability, particularly where you have target assets spread across the world and multiple jurisdictions. Arbitration has the other advantage, of course, of being private. The proceedings are not in open court. So that can be an advantage. Of course, there are pros and cons to everything. There are costs to arbitration, arbitrators, availability becomes a factor in determining timelines. So, there are things that need to be thought through. But those are the lenses through which most parties tend to view this issue.
Great. I think that was very well covered. And the question was from one Mr. PG is all that I see. We don't have the full name, but I hope Nikhil was able to clarify the query. And if you have any follow-up questions, you can always drop us an email. I would only add, Nikhil, to everything you said. We also see this applicability of bilateral investment protection treaties. And one should be mindful when doing cross-border deals, whether there's a BIT that exists between the countries. So you also have a second level of protection to rely on BITs if you were to go against the state to seek protection. So that is one more element. Let's see, maybe we can take uh, questions from one more question from the audience list, and bear with me for a second as I try and pull out the next question. Yeah. Okay, so we have the next one, and this is from Raghav, who's asking, what is the market experience in terms of integration and ongoing management, and how relevant is integration as part of M&As? And Samir, I know you've been involved in some recent deals which had an extended integration period. So why don't I turn this question to you and ask you to respond to it?
Right. I think that, frankly, in our experience, sometimes tends to involve a lot more uh, thought even prior to the transaction. But you're right, Anuj. If somebody is asking this question, they're asking the right questions, because we often see clients give insufficient attention to this in the heat of the deal. And we feel that the real work begins only after the transaction. That's when you start sweating the asset and realizing the value for which you've actually engaged in that entire process of going through due diligence, negotiations, eventually putting your money where your mouth is. And many well strategized deals, we've seen them ultimately fail because while the initial plan wasn't flawed, the execution afterwards was very poor. And if I have to create a few buckets, I would really say there are, to my mind, four buckets. The first, Nikhil spoke about cultural integration, and this is really practically a merging of two sets of people with perhaps very different corporate cultures, very different management styles, expectations of stakeholders. This requires very careful and sensitive communication. I can tell you in one instance, we noticed that one of our clients acquired a business in two or three of the Asian markets put together. And our clients had a very aggressive, fast paced communication style, which is very akin to a lot of Indian companies. And believe you me, in the target management, this was perceived as very confrontational. And at times it created a lot of internal friction. And the client subsequently told us that they spent a lot of time in cross cultural training to really bridge these gaps. I would say the next, after you've dealt with these softer aspects, is really operational integration. And in one transaction in the UK, our client was buying a company out of administration, which is their equivalent of insolvency. We found that the HR records were woefully incomplete. There was a whole host of issues from a pensions perspective, which we really didn't know what to do about. And even though the business was bought out of administration, there is a law which passes on a lot of the employee responsibilities to the buyer. And the legal and operational teams really had to work overtime to reconstruct those records. In a different transaction, what are the key priorities the client got down to post the transaction? It was in the life sciences space, was really aligning the documentation and quality control systems of the acquired entity with the global standards that our client was used to. It required a complete overhaul of all of their paperwork and practices. The key thing is, while this was an operational integration post transaction, both of these observations came out of a great a precise due diligence exercise which had been carried out. So you learn of issues before, plan, and thereafter execute those later. I would say legal and regulatory integration seems to also be a problem. We've seen instances where Indian acquirers struggle with the entire place of effective management issue, which is an Indian tax concept which states that if a company abroad essentially has its place of effective management in India, there's a risk it could be a tax resident of India. Can you imagine? And then therefore having the right feet on the ground, having your management locally present and take decisions, it can be very challenging. And this sometimes leads to not having a clear direction. And I would really say the last item is talent retention, and that can be one of your largest challenges. One example which comes to mind is not having thought through the incentivization of the employees. So we had a client who looked at a European target. It so transpired that there were great synergies in the product portfolios. And eventually, the customers to whom the Indian clients' sales teams were pitching, the same customers were being pitched for by the European target business's sales team. As a result, they wanted a similar incentive structure to be created for both of them. And the easiest, of course, was to migrate the target to the incentive structure being followed by the acquirer. But believe you me, it led to a mini mutiny because the incentive structure just was not clear to the target. And therefore, they really had to work the other way around, create some sort of a hybrid. So one can't talk enough. It's a minefield of legal, cultural, and operational challenges. But so long as you've had a disciplined and multidisciplinary approach, you've done your diligence well, and you have a clear integration plan, these are things that can be resolved. Over to you, Anuj.
Yeah, I think we you covered it, explained it well, Samir. We had a follow-up question in the audience questions page from Anshita Naidu, which and the question was, speaking of cultural sensitivity in transactions, could you share some examples of cultural due diligence? But I think you already covered it, so maybe we can move on. And I see we are running out of time as well. But as a concluding note on this favorite topic of ours of cultural aspects, one of my favorite stories is of Renault and Nissan ultimately leading to Carlos Ghosn being smuggled out of Japan, or smuggling himself out of Japan. But it was one of these classic cases of cultural alignment, and an interesting story to read as well. So, and I see we are totally out of time here. We have a few more questions. Apologize, we will not be able to address them on this call, but we will. You posted your email addresses, and we'll see to it that we reply to each person who's posted these questions separately. So let's move on. I think so. The last thing before we conclude, one of the things I am supposed to do is give everyone a set of key takeaways, and I'm looking at my notes, and some of the key takeaways, if people don't remember too many things and they just want to take a few things out of this webinar, I think just a second, the key takeaways from this webinar, I would say the 5 key ones would be: plan early and get the right advisors, understand the market practices, deal timelines, regulatory approvals, financing options, and set up a decision-making team from day one. I would say the second one would be navigate Indian regulatory limits smartly. There is a confluence of ODI, OPI rules, investment caps, pricing guidelines, and sector restrictions. So you need experienced advisors and to handle you through these complex regulatory rules. Be financing ready. Nikhil, you raised this, and offshore funding could be cheaper, but comes with RBI constraints on guarantees, pledges, and Indian asset security. Don't stop at closing. I think we talked enough about integration, and post-merger integration, cultural alignment, and retaining key talent are critical to realizing deal value. And stay very alert to national interest reviews. Governments across the board are getting nationalist, and there's a lot of desire to make everything within the same country, not to import stuff. So there's a lot of screening regimes in the US, UK, EU. India has its own regimes. So stay alert to national interest reviews. I think these were my top takeaways from this session. If I have to just pick up 5, but if anyone wants to add, feel free. Okay, I think we're totally running out of time. And before closing, I'd like to ask each of you to respond to the poll slide on the screen to provide your feedback on today's webinar. We take this very seriously as part of our continuous improvement program. Okay, looks like we did a good job. Great. So thanks to everyone who participated in the poll. Finally, I would like to thank all our presenters for sharing their expertise and experience with us today. You were great. Thank you so much. Also, thank you to our audience for your attention and for your questions. I hope you found the webinar interesting and a worthwhile investment of your time. We certainly enjoyed bringing it to you. After the webinar, we will send you copies of today's presentation materials, summary notes, and a link to the webinar recording. You will also separately receive a request for your feedback on the webinar. Please take the time to send us your feedback, comments, criticism, compliments. Uh, the form takes less than a minute to complete. If you are interested in in-house training or any other matters arising from this webinar, please do not hesitate to contact us. Our contact information is on the contact slide on your screen. Thank you for your attendance today, and we look forward to being with you again at M&A Masters. Thank you.
Thank you, everyone.